Greetings to Madam. This is our group's video presentation for the contract project. We are from Tutorial 3. My name is Inchira and I am the group leader. My group members consist of Elena, Kaylee, Renisha and Suhesh. This is the full question, but I'll be starting us off on the first paragraph on whether the advertisement here is an invitation to treat or a contract. So the parties consist of Ida, a nurse with sensitive skin, who purchased the product Immunipatch from Cepat Sihat Sendirian Berhad, a pharmaceutical company. So Ida claims that she is entitled to 10,000 ringgit as compensation as provided in the advertisement, while Cepat Sihat states that the advertisement was merely a promotion and there was no intention to pay anybody. So the issue here is whether the advertisement by Cepat Sihat was an invitation to treat, or did it amount to an offer that will be legally binding between the company and Ida, thus allowing Ida to claim for compensation. So the laws to be applied would be invitation to treat, Section 8 of the Contracts Act 1950, Partridge against Crittenden, Carlisle against Carbolic Smokeball, and Coil against the Public Services Commission. So, applying invitation to treat. This is a legal principle whereby a statement made is not intended to be legally binding at law. However, it is merely an invitation for parties to make an offer. So looking at the advertisement given by Cepat Sihat Sendirian Berhad, over here at the bottom, it can be said that this is actually not the intention of Cepat Sihat Sendirian Berhad is not for their advertisement to be an invitation to treat, which advertisements usually are, because they have provided the consideration, which is the 100,000 ringgit, and they have shown their intention to create legal relations by depositing this consideration into June Bank. So this is the conduct by Cepat Sihat Sendirian Berhad. What is the conduct by Ida? This is where Section 8 applies. So Section 8 is whereby a performance of the considerations in a proposal and the acceptance of any consideration for return promise is considered an acceptance. So Ida's conduct is that she has done the performance which is required by Cepat Sihat in their advertisement. So this is why Section 8 applies, because her performance is considered to be an acceptance. So, looking back at the statement here, 10,000 ringgit will be paid to anybody who uses the Immunipatch daily for 30 days as directed and still develops a severe skin allergy. So, they will be compensated. So, this makes the ad, going back to the previous invitation to treat, this makes the advertisement, which is usually an invitation to treat, turning it into a unilateral contract. So, this becomes an offer to the world at large. So, I would like to show this by applying the case of Partridge against Crittenden. So in this case, the appellant had placed an advertisement in the newspaper under classified advertisements for Bramblefinch birds. The court then held that in law, the insertion of classified advertisements is merely an invitation to treat and not a binding offer. So this is why advertisements are generally considered to be invitations to treat. However, we have to look at the intention of the parties. So applying this to the facts in the question, Cepat Sihat Sendirian Berhad had shown their intention to create legal relations via the consideration placed into the bank. So this means it has become a unilateral contract. It has become an offer to the world at large. That means whoever who performs is entitled, and the person who performs, which will be Ida, she has accepted the offer. This is why there is a contract between the both of them. So the facts of the question applies closely to Carlisle against Carbolic Smokeball, whereby in this case, Carbolic Smokeball Company had posted an ad to pay £100 in reward to anybody who uses their product and still contracts an illness. This is what Mrs. Carlisle did. However, the company denied and said that it was merely an invitation to treat. So the court held that an advertisement can be an offer to all the world or the world at large when it is accepted by the performance of the conditions. So this is exactly what happened in this facts of the question over here, whereby Cepat Sihat Sendirian Berhad had turned their advertisement into a contract into an offer to be accepted via the performance of a person, which would be Ida. Now I would like to apply the Malaysian position, which is can be seen in the case of Coil against the Public Services Commission. So in this case, the Public Service Commission posted an advertisement in the Malay Mail inviting applicants for the post of Assistant Passport Officer. The applicant, which is Coil, he received information that he had been selected for the appointment, but it was later informed that his appointment, which was on probation, was terminated and then he was given payment. So this is why the case was brought forward. So the court held here that the Malay Mail advertisement was merely an invitation to treat for qualified persons. So this shows again a contrast to the facts in the question, whereby invitation to treat is actually what invitation to treat is actually what an advertisement is meant to be. However, you have to look at the intentions of the parties. So looking at the facts in our question, the conduct by Cepat Sihat Sendirian Berhad in their advertisement, by providing for the consideration, by putting it in June Bank, this shows their intention to create legal relations, thus turning their advertisement into a unilateral contract. So it does not become an invitation to treat any longer. So this is how it contrasts in the Malaysian position. So in conclusion, Aida should be compensated as stated in the advertisement by Cepat Sihat, as she had accepted this legally binding offer and she had contracted a skin allergy after that, after using the Immunipatch. So she is entitled. However, a suggestion can be given to Cepat Sihat in the future when making advertisements. They should avoid making unilateral offers. So the advertisement should be strictly invitation to treats rather than making it into an offer. So by to do this, they should remove any evidence of any intent to be bound or to create legal relations, such as don't include the 100,000 ringgit deposited into June Bank. So that will make it an offer rather than invitation. So they must explicitly state their terms as invitation to treat rather than making it into an offer. And that will be all from me. I'll now be passing on to the next person. Thank you.
Hello everyone, I am Kaylee and today I will be presenting paragraph 2. So paragraph 2 consists of, meanwhile, Aida's father, Rahman, had entered into an agreement with his close friend Johan. Both men agreed that if their children, Aida and Johan's son Hafiz, married each other, each father would give 50,000 ringgit as a wedding gift to the couple. When the marriage actually took place, Rahman fulfilled his promise. However, Johan died before making payment. So, Hafiz and Aida tried to claim the 50,000 ringgit from Johan's estate, but Johan's executor refused, arguing that they were not parties to a contract. So, what is the main issue here? Well, the main issue is whether or not Aida and Hafiz, who are third parties, can legally enforce a contract that was made between their fathers, Rahman and Johan. Specifically, the question is whether they have standing to sue Johan's estate for the 50,000 ringgit that was promised upon their marriage, or whether the executor is correct in refusing payment based on the doctrine of privity of contract. So, in the privity of contract, under the doctrine specifically, only parties of a contract can enforce this. This principle was clearly established in a case titled Tweedle vs. Atkinson, where two fathers promised to pay money to their children upon their marriage, but the son could not sue because he was not in the party. Similarly, in a case, the agreement was made between Rahman and Johan, their fathers, not them itself. So, therefore, the strict rules in Tweedle is applied here as well, and Aida and Hafiz would be barred from enforcing this promise. So, however, there is consideration here. Consideration is an essential element in a valid contract. In this case, valid consideration clearly existed between Rahman and Johan, because each of them promised to pay 50,000 ringgit upon their children's marriage. This confirms that a binding contract existed. So, Section 2D of the Contract Act 1950 allows consideration to be moved from a third party, meaning the Privy Council in the case of Kepong Prospecting Ltd vs. Smith made it clear that this does not abolish the doctrine of privity. Applying this case, although the contract is valid, Aida and Hafiz remain strangers to it unless an exception to privity applies. So, Malaysian flexibility. Malaysian courts have shown multiple flexibilities in applying the doctrine of privity in courts. In a case titled Chin Swee On vs. Golden Horse Motors, the court recognized that this is a strict application of privity may result in injustice, and that the court should look at the substance rather than just the form of the transaction itself. In this case, specifically, the agreement between Rahman and Johan was clearly intended to benefit Aida and Hafiz. the 50,000 ringgit payment was not incidental but the very main purpose of this contract itself. So, therefore, applying Chin Swee On case to this context, the court may allow enforcement and give effect to the parties' intentions. Next, it's the effect of death. Under Section 38 of the Contract Act 1950, contractual obligations generally bind the legal representatives of a deceased person unless the contract requires personal performance. In this case, Johan's obligation to pay 50,000 ringgit. This is not a personal obligation, and therefore his death does not discharge this contract itself. If enforceable, the obligation continues against his state. So, trust and agency exceptions. While other recognized exceptions to privity include trust and agency, however, neither applies in this case here. There is no indication that Rahman intended to create a trust for Ida and Hafiz, nor is there any evidence that Ida and Hafiz authorized their fathers to act as their agents on their behalf. Therefore, these exceptions cannot be relied upon. So, in conclusion, although a strict application of the doctrine of privity can be seen in Tweedle versus Atkinson, that would bar Ida and Hafiz's claims. Malaysian courts have adopted a more flexible approach. Given that the contract was clearly intended to benefit them and denying enforcement would defeat the parties' intentions, the exception recognized in Chin Swee On's should apply. Johan's estate remains bound under Section 38 and therefore Ida and Hafiz have very strong legal grounds to succeed with their claim. That is all for my part. I will pass it on to the next person.
Hello, my name is Suresh Kumaran and I'll be discussing paragraph 3, the dilemma in relevance to intentions to create legal relations. So the facts of this scenario is that, firstly, the parties that are involved in this case is Ida and her mother, and they represent a familial domestic relationship. The contents that were made in the agreement between Ida and her mother, where Ida had accepted the offer by her mother to leave her job and study full-time, and her mother had made the offer and promised in return to Ida to pay 2,000 ringgit allowance monthly till her graduation. However, due to conflicts arising between both parties, the mother had stopped the payment of the allowances. So the claims by both parties, the mother had refused to continue the payment as she justified that the family agreement is not a contract and she is not supposed to be legally bounded or contractually bounded by the agreement. However, the daughter had claimed that the contract was valid and in fulfilling her promise of studying abroad and sacrificing her job, she should receive her monthly 2,000 ringgit allowance. The main issue in this case is whether the contract formed between the mother and daughter would be regarded as legally binding and would require the mother to fulfill her promise as she made. The main principle that we will be applying is the intention to create legal relations. The significance of this principle for this case is that we will be determining the motive for the parties entering the contract, in which would they be bearing legal consequences or not. We'll be also utilizing the objective test, where we'll be deducing the circumstances and the facts that were involved between the parties in the making of the agreement to determine whether it was legally binding or not. The general rule of application for cases of social and domestic relationships is that there is no intention to create legal relations in the contracts and agreements between these relationships. The reason for this is because these affairs are the responsibility of the individuals in the domestic relationship and are not to be determined by law, as defined in the English law case Balfour v. Balfour 1999, where the decision of the court held that the agreement was not an enforceable contract between the couple because the parties did not intend for it to be attended by legal consequences. The rationale that we can infer from this common law case is that in social and domestic agreements, especially between spouses and family members, there is a rebuttable presumption that the parties do not intend to be legally bound. This is also reflected in the Malaysian position case of Tan Hong Sang v. Tan Hong Kim and another, where the decision in court held that the agreement between both parties was a private family matter meant to help the son save money rather than a commercial contract. And well, this enforced the application of the domestic presumption within the local context in Malaysian cases. Now, However, there is exceptions to these domestic agreements where there can be attention to create legal relations under specific types of agreements. Firstly, the consideration where the parties are not living in enmity or are not peaceful. Another condition is that the agreement was written and instead not done orally, where this could fulfill the requirement to be legally binding to fulfill the contract. This was applied in the case of Mary Married, where the Court of Appeal held that Miss Married had been in favor and would dismiss the husband's appeal, where the court held that the presumption of no legal intent does not apply when the parties are no longer living in enmity, where in this case they were divorced, and also the reason because the agreement was in writing, which further solidified the serious intent between both parties. Now, we'll be applying the principles that we have talked about and analyzed to this scenario. We'll also be utilizing the case of Jonas v. Paddington to be, which is really helpful in drawing more effective analysis and use of principle due to the very similar situations. Firstly, the agreement between the mother and daughter, where the nature of the relationship is domestic. Number two, both daughters were offered to study abroad, and the promise was done orally. And third, the disagreement would result in the mother taking back their word, where in Jonas v. Paddington, the mother took the position of the house she had bought her daughter, and in this scenario, Ida's mother had took away the supply of allowance from Ida after 1 year of her studies. Now, in the scenario of Ida and her mother, the determination of whether there was intention of legal relations must be applied through the nature of the agreement of the relationship prior to the agreement, where it shows that they were living in enmity through the assent by Ida to the mother's proposal a year ago, where this also can be seen in the case law that we have applied in Jonas v. Paddington, where Miss Paddington also showed assent to her mother's proposal to study abroad. Next, the medium in which it was exercised to make the agreement between Ida and her mother, it was clearly ambiguous in this scenario, but we can assume it was done orally due to the lack of any statement on any written agreement, and this would infer that there is no intention to create legal binding. Where in the case of Jonas v. Paddington, the medium was clearly stated to be made orally. Next, in this precedent case of Jonas v. Paddington, the court held that this was only a family agreement and the parties held no intention to create legal relations in the agreement. Now, that would result in the conclusion of the scenario where there was no intention to create legal relations between Ida and her mother, and this is highlighted through two factors. The agreement was made when the relationship was living in enmity, and there was no evident written agreement between the parties. This would infer that the mother is not legally required to continue the payment of 2,000 ringgit monthly. However, there are recommendations for Ida. Ida will be able to dispute this agreement if she's able to prove that there was serious intent in the agreement when it was made, and this could be utilized in utilization of valid consideration for the promises under Section 2(3) of the Contracts Act 1950, where the sacrifice of a nursing job to study in return for a consistent provision of allowance would make for a legally binding agreement. This could also be evident through her performance of her part of the agreement through the endeavor of studying for 1 year. Yeah, and that would be the end of my part. I'll be giving it to the next person. Thank you so much.
Hello, I am Renisha and I will be answering for paragraph 4. So finally, after completing her studies, Ida joined the Ministry of Health under a 5-year government scholarship bond. 2 years later, she resigned to work overseas. The government demanded that she repay the entire bond amount, but Ida argued the terms were unfair and constituted a penalty. Now, the parties involved in this case is the Ministry of Health and Ida. The Ministry of Health claims that Ida should repay the entire bond. Meanwhile, Ida argues that it is unfair and constituted a penalty. The agreement was that Ida joins the Ministry of Health under a 5-year bond, but the main conflict is that Ida had resigned within 2 years. Now, the issue is whether the government can demand the repayment of the entire scholarship bond amount from Ida, despite her having served 2 years of the 5-year bond, or if Ida is correct in arguing that the terms are unfair and constitute a penalty. Now, the rules in this case is Section 75 of the Contracts Act and Section 5A of the Contracts Amendment Act. Now, first, the Section 75 of the Contracts Act, this is a general rule. It protects people from unfair penalties, and it says that if you breach contract, you should only pay reasonable compensation for the actual loss caused rather than the massive fixed penalty. Ida is using this to argue that she should pay less because she served 2 years. However, Section 5A of the Contracts Amendment Act 1976 overrides this general rule and provides that for scholarships, it creates a strict liability and states that if a bond amount is named in the agreement, the scholar must pay the whole sum. Aside from these two relevant provisions, there's also two other relevant case laws: University of Malaya against Lee Ming Chong and Lee Ming Chong 1986 and Government of Malaysia against Gurcharan Singh and others 1971. Now, in the case of University of Malaya against Lee Ming Chong, the brief facts is as follows. University of Malaya appointed Lee Ming Chong to a scholarship to study in Canada. The agreement was that Lee must serve the university for at least 5 years when he returned. However, when Lee returned, he had only served for 2.5 years and he had refused the university's offer promotion and also he had resigned. The university then sued for $5,000 while Lee argued that he had fulfilled the scholarship's agreement. The court ruled in favor of the university and ordered for the full payment of $5,000. As Lee was liable due to the breach, as his partial service did not absolve him from paying the sum, nor did it entitle him to a reduction of the sum. Then there is the case of Government of Malaysia against Gurcharan Singh and others 1971. In this case, Gurcharan Singh was sponsored by the government to attend a teacher's training course. At the time of signing, he was 17 years old and 11 months. The contract required him to serve the government for 5 years after completing the course. Gurcharan resigned after serving for only 3 years and 10 months. The government sued him and his sureties for $11,500, which was the amount spent on his education. Gurcharan argued that since he was a minor, the contract was void. The judge held that the government was entitled to be reimbursed by the first defendant since the sum sponsored for his education and training were treated as necessities. Now applying this to the facts. The main breach is that Ida had resigned within 2 years and did not fulfill the 5 years as stated in the scholarship agreement. Now, Ida argues that demanding the full amount is unfair and constituted a penalty. But in general contract laws, penalties are unenforceable, which is true for the case of Ida's argument. However, because this is a scholarship agreement, Section 75 cannot be applied, as the Contract Amendment Act 1976 applies, specifically Section 5A. As well also considering the ruling in Lee Ming Chong, which says similar facts to the case with Ida and the Ministry of Health. Similar to Lee Ming Chong, Ida had only served for 2 years instead of 5 years, and therefore the Ministry of Health is entitled to recover the full bond amount, as Ida's partial service does not absolve her, nor does it entitle her to get a reduction in paying the bond amount. So Ida's argument that the bond is an unfair penalty is invalid under the law. And even if Ida was a minor, as seen in the case of Gurcharan Singh, Ida would still be entitled to pay the full bond amount. In conclusion, Ida is legally obligated to repay the entire bond amount. Her argument will fail due to Section 5A, as it strictly enforces scholarship bonds to ensure public funds spent on education are recovered if the scholar does not fulfill their full service tenure. This has been upheld in the case of University of Malaya against Lee Ming Chong and as well in Gurcharan Singh. And that for Ida is legally obligated to repay the entire bond amount and the Ministry of Health is in the right with their claim. That is all from me. Thank you.
Hi, my name is Elena binti Ibrahim and I'll be presenting on paragraph 5, in which at the same time Ida planned to buy a house in Seremban from Laila, a property agent. Laila offered to sell the house for 1,000 ringgit and Ida replied offering 550,000 instead. Laila rejected the counter offer. A few days later, Ida changed her mind and wrote back, I agree to buy at 500,000 ringgit, and Laila refused to sell, saying the offer was no longer valid. So Laila is the offerer and Ida is the offeree. In the sentence, at the same time, Ida planned to buy a house in Seremban from Laila, a property agent. Laila offered to sell the house for 1,000 ringgit. The scene changes when Ida becomes the offerer and Laila becomes the offeree. In the sentence, Ida replied to Laila by offering counter offer 450,000 ringgit instead of accepting or declining Laila's offer of 500,000 ringgit. Laila rejected the counter offer. A few days later, Ida changed her mind and wrote back, I agree to buy at 5,000 ringgit, and Laila refused to sell, saying that the offer was no longer valid. So the issue is whether a valid contract exists between Ida and Laila, if Ida's previous agreement to buy the house for 5,000 ringgit constitutes a valid acceptance of Laila's original offer, or if the original offer had already been terminated by Ida's counter offer. So in the Contracts Act, Section 2A states an offer is made when one person signifies to another his willingness to do or abstain from doing something. Section 2B states when the person to whom the proposal is made signifies his assent to the proposal is said to be accepted. So the counter-offer principle in Section 7A states that an acceptance must be absolute and unqualified. If a party introduces a new term, such as a different price, it is not an acceptance but a counter-offer. In the case of Hyde and Ranch, the defendant offered to sell an estate for £1,000. The plaintiff replied offering £950. The defendant refused. The plaintiff then tried to accept the original £1,000 offer. The court held that no contract existed because the counter offer of £950 terminated the original offer of £1,000. Once an offer is rejected or countered, it cannot be revived by the offeree. In the case of Malaysian Floor Mills Berhad and Saw Ng Chee, the court applied the doctrine of counter-offer to rule that the plaintiff's response failed to create a binding contract under Section 7A, which mandates that acceptance must be absolute and qualified. The plaintiff's managing director proposed to purchase 4 lots of land for an increased total price instead of accepting the single lot offered in the original telex. The court determined that this material variation of the subject matter and price constituted a counter-offer. This counter-offer had the immediate legal effect of rejecting and destroying the original proposal, rendering it incapable of being subsequently accepted by the plaintiff, and ultimately, the court held that no concluded agreement existed because the introduction of new terms indicated that the parties had not reached a final consensus ad idem and were still engaged in negotiation. To differentiate counter-offer and mere inquiry, we can look at the Malaysian case of Lau Brothers & Co. and China Pacific Navigation Co. Limited. In this case, the court dealt with the negotiation regarding the delivery of logs. The parties were communicating via telegrams and letters, and when an offer was made, the other party replied by introducing new terms and conditions that were not in the original proposal. The court held that by introducing new terms, the party had made a counter-offer. Under the principle of absolute and qualified acceptance, Section 7A, any revision to the original terms rejects the offer. Therefore, no binding contract existed because the original offer was destroyed by the counter-proposal. For mere inquiry, in the case of Moneta and Seribis, Estonian Berhad and others, the principle is applied to determine if a party is simply probing for more information. A party asks a question, such as, will you be open to payment by installments, or does the price include a delivery, without explicitly rejecting the original price or terms. If the language used is inquisitive rather than propositive, the Malaysian courts treat this as a mere inquiry. A mere inquiry does not constitute a rejection. The original offer remains alive on the table, and the offeree can still return to it and accept it after receiving the information. In the case of Transwater Tenaga Sdn Berhad and IPS Technologies Sdn Berhad, the Malaysian Court of Appeal reaffirmed the strict mirror image rule of contract formation under Section 7A, ruling that an acceptance qualified to be valid. The court held that the plaintiff's request to escalate the price during negotiations constituted a counter-offer rather than a mere request for information. By introducing a material variation to the price, the plaintiff effectively rejected the defendant's original offer, causing it to die legally, and consequently, the plaintiff's subsequent attempt to accept the original lower price 2 days later was ineffective, as there was no longer a valid offer in existence to be accepted. So in the application, Laila made a valid offer to sell the house to Ida for 500,000 ringgit. Instead of accepting, Ida replied with an offer of 450,000. This is a counter-offer. Applying the principle in Hyde and Ranch, this counter-offer acted as a rejection of Laila's original offer. Once Ida proposed 450,000 ringgit, Laila's offer of 500,000 became invalid. It doesn't exist anymore, so Ida can accept later. When Ida wrote back saying, I agree to buy 500,000 ringgit, it's not accepting an old offer but a new offer to Laila. Since Ida's last message was a new offer, Laila has the right to accept or reject it. Laila chose to refuse. So in conclusion, Laila is not legally bound to sell the house to Ida. There is no binding contract because the original offer was terminated by Ida's counter-offer. Laila is free to sell the property to someone else or negotiate a new price. Ida cannot sue for breach of contract. Her counter-offer of 450,000 ringgit effectively destroyed the original offer of 500,000. If she wishes to buy the house, she must wait for Laila to issue a new offer or hope Laila accepts her latest proposal. That is all from me. Thank you.